Hi, folks. I'm Denise Howell, and you're about to join us for episode 400 of This Week in Law. Matt Curtis, Emory Roane, and Gabby Ziccarelli are here with me today, and we are all about not disrespecting the Wu-Tang Clan, not getting paid for your IP rights, or at least thinking about it before you decide not to get paid. We are about not forum shopping for patent venues, and the EFF leaving the W3C. All of this and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, Emory Roane, and Mike Keys. Episode 400, recorded September 22nd, 2017. Advercacy. Hi, folks. You're joining us for This Week in Law. I'm Denise Howell, and yay, you've picked a great episode to join us for today. It's our 400th episode of the show. We're very excited to be here to celebrate that momentous event with you. We've got a great panel of folks. Woohoo! Oh, even special on the video. Great panel of folks joining us today. Gabby Ziccarelli is back with us today. Hi, Gabby.
Hi, how's it going?
It's going great. So excited you could join us this week for our 400th episode. Gabby is an advisor to the incubator Seat Spot. She's an Internet Law and Policy Foundry Fellow. She's the co-host, too, of her own new podcast, which I just did. So you can catch me on Gabby's new show fairly soon here. It is called Hustle Over Entitlement. So, Gabby, it's great to have you back.
Oh, I'm thrilled to be back. I missed y'all.
We've missed you, too. Also joining me today are two of my wonderful, wonderful co-hosts, two members of the TWiL family. We've got Emory Roane. He, too, is an Internet Law and Policy Foundry Fellow. He's a recent grad of California Western School of Law. He is a current bar result waiter person. Yes. California Western School of Law is home of New Media Rights, where Emory has been an intern, and Emory was an intern for us as well. And great to see you again, Emory.
Yeah, thanks for having me back. As always, it's super fun and exciting, and I can't wait to get into it. And the 400th episode, are you crazy? That's awesome. 400 episodes of TWiL.
And Denise,
so listeners, when you get tired of this episode, go back.
Do I need to change Emory's lower third to bar awaiting person?
Oh, please don't jinx it.
Future attorney.
And sorry about the explosion. I was going for fireworks, and that wasn't a firework.
You just blew it all up.
Bam.
I love it. It was celebratory, Victor. I'll go with it. What else did I want to ask you? New Media Rights. I had the opportunity to refer someone there recently, Emory, because it seemed like the perfect fit for this person's legal needs. Remind us what it is again. We've had not just you, but other professors of yours on the show that work with New Media Rights.
Yeah, great. That's awesome. New Media Rights is a nonprofit here in San Diego. They offer reduced fee, pro bono, low bonus support for artists and entrepreneurs. They also have a huge store of educational resources on their website. They published a book, an ebook, and audiobook recently that you might want to check out called, do I have it up here? Don't Panic. I don't have it on hand, but
that's the name of the book. You're not just telling yourself not to panic.
I always tell myself not to panic, but that is also the name of the book.
Perfect.
But yeah, they offer free support for basically anyone. If you have a question, if you're an artist, entrepreneur, you can fire off a contact form to them and they'll get back to you quickly. And it's a great nonprofit to support. So glad that you could send someone over there.
Yeah, absolutely. They are just chock full, aside from actually providing you with legal representation if you need it. If you are just wondering if you need it and you want to educate yourself some more, so many great resources over there for free on their site about tons of the issues we talk about on the show. Things you should be thinking about if you're a creative of any kind online. So it's a super valuable resource there. And there's Don't Panic.
There we go. Don't Panic, a legal guide in plain English for small businesses and creative professionals. So it just gives you a lot of the ins and outs of some of the IP and privacy and startup issues that can trip you up before they trip you up. So check it out. It's like $10. Yeah.
Super important guidance for whether you're, just a person who uses social media. I would recommend that you have this on hand to consult with. And
in fact, it might be useful for an article we might talk about today.
It might well, yes. Also with us is Matt Curtis, who's a law student at Notre Dame School of Law and a soon-to-be audience member for the Slants. I'm so excited about this, Matt.
Yeah, because of the connection we had with the Slants coming on here on TWiL, we've got them coming here. They're going to play at the courthouse, and it'll be really great. But I just want to congratulate you, Denise, on 400 episodes. That's a tremendous accomplishment.
Oh, thank you so much. I couldn't have done it without you guys, as you well know. So it's just great to be here celebrating this milestone with some of my favorite folks and our audience's favorite folks, and some really great topics to get to today. I think we're going to start with the copyright stories. When Naruto's in the news, we lead with Naruto, and that is what we're doing here today. I'm not sure if we always follow that rule, but we try to. We mentioned an issue with the settlement, the monkey selfie settlement, where PETA sued photographer David Slater and Blurb, his publishing platform, for a book that included the famous photo of the Indonesian macaque named Naruto, asterisk that, various experts and testimony in the case, and those who in the know on the issue think that maybe it's not actually Naruto in the photo. Hashtag monkey truthers. Anyway, we mentioned at the end of, I think it was the last show, that the case had settled. The parties have asked the court to dismiss the case, but they've also asked the court to do something that we thought might be a little controversial, and it turns out we were right. They've asked the court it's at the appellate court level now. The Ninth Circuit Court of Appeals heard oral arguments on the case, but never issued a ruling, is not going to issue a ruling now that the parties have settled, and asked the Ninth Circuit to put on the brakes. But what they've also asked the Ninth Circuit to do is to undo the decision of the lower court, the trial court, which actually made a legal finding, and federal trial court opinions are published. So it's citable. It's something out there that people could refer to as legal authority on this issue. And what that court found was that there was no copyright in this photo because animals can't have copyrights in things. In other words, the court agreed with the U.S. Copyright Office, who has stated that as well. So PETA and David Slater, and I'm sure this was at the behest of PETA, have asked the court to undo that, presumably because PETA thinks that it may bring this kind of lawsuit again or just doesn't want further legal authority around that says that animals can't hold copyrights. So there is an amicus brief that has been filed now taking issue with this by the Competitive Enterprise Institute, which is some kind of think tank. I was not familiar with it before they filed this brief. But they have come in and said, look, you can't have it both ways, PETA. PETA is saying that we can go along and undo the lower court's action because, in fact, Naruto is not a party to the settlement, so shouldn't be bound by what the lower court did. I don't know. It's sort of strange logic. If you ask me, I kind of agree with CEI on this. But since PETA argued throughout the case to be in the position of representing Naruto under the next friend doctrine, CEI is basically saying you can't have it both ways, and that the rule in situations like this is you have a voluntary settlement. It doesn't, that deprives the Ninth Circuit of jurisdiction to do anything besides dismiss the case, and that it can't go down and vacate the district court's order. So it's a short amicus brief that was filed with the Ninth Circuit, and the Ninth Circuit may have concluded this anyway on its own, by the way, without CEI. But we don't know. It hasn't ruled yet, but it gives us the opportunity to once again ponder whether Naruto had a copyright and it could be properly asserted. Emory, any thoughts?
I just really, I think that there is going to be at least one law school professor that structures an entire class about the ins and outs of this case, because it has touched so many different areas. And it's always interesting when, civil procedure rears its ugly head and, puts the smackdown on people. So, there's, I don't really have anything that you didn't say already, or CEI said as well in their brief.
Okay, how about you, Gabby?
So I'm going to be the negative one here and look to intention. Why would you want to undo it? I'm thinking that if we get rid of that, we clean the slate. Does PETA get a free for all on other potential animal selfies? I mean, thinking about why you wouldn't want that to stand and what that might mean long term. I know on my episode I was on a couple weeks ago, we talked about this and, where do we draw the line? Do we think about robots and all of that? Another question I have just for the panel is, let's say this is undone. What does this mean for other IP that may be created by non-humans? I was looking at the patent laws, and technically they say whoever invents, et cetera, et cetera, et cetera. So, what would an undoing do in this situation?
I think that we have an article in the show notes on Lexology called Monkey See, Monkey Do, Monkey Own, the Curious Case of Naruto v. Slater that brought up some really great analysis as well. And they brought up that the Copyright Office's guidance is in, I think, December 2014. So it's not law, but the Copyright Office recommends at least that to qualify as a work of authorship, a work must be created by a human being. Works that do not satisfy the requirement are not copyrightable. And specifically, they highlighted a photograph taken by a monkey as an example of what the Copyright Office at least considers would be uncopyrightable. So it's not, strict law yet, but it does play into the decision.
Right. And to answer your question more directly, Gabby, I think undoing this doesn't do a whole lot. District court decisions are not terribly authoritative to begin with. I mentioned a moment ago, it could be cited as authority for proposition. It is a court backing up what the Copyright Office said in its guidance, as Emory just reminded us. So it's one step further down that road, but it's not like a terribly authoritative step. So I really don't think it's that important one way or the other, whether it stands or doesn't stand. And I do think that the Ninth Circuit may decide, hey, procedurally along the lines of CEI, what CEI has had to say, if you want us to get out of the case, we're getting out of the case, and we're not undoing lower court things when we get out of the case. That's called making a determination on appeal, and that's what you've asked us not to do here by voluntarily settling the case. So I think they have that problem as well. What do you think, Matt?
Yeah, I think that the vacator is left to the discretion of the courts. And so the situations where the court is determining if there's a new fact that comes up or something like that, it may make sense for parties to stipulate to a settlement and then determine that, part of the settlement is that we're going to ask for vacator. But this case was the court determined a question of law, which is that animals don't have standing for copyright. And so in this instance, it doesn't make any sense why the court would want to vacate this, especially in that they had gone to the Ninth Circuit and had heard oral argument. So this is like, this is far beyond it seemed like the judges were very hard on PETA. And so their willingness to go back and vacate the underlying claim or the underlying judgment doesn't seem like a very promising prospect.
All right. Well, we hope to be able to continue to talk about Naruto and his case, and we'll certainly follow up and let you know what the Ninth Circuit decides to do. For the time being, we don't know what that will be, but we do know that the parties have settled. So our ability to talk about the case is winding down, to be sure. Something probably far more important and long-term current. Actually, I don't know. Who owns copyright is a pretty important issue, but so I'm not going to back off that stance. But something really interesting happened this week, something that would trigger your wow emoticon at minimum, and that is that the EFF has resigned from the W3C, and it has resigned over the issue of what's called EME. Which stands for, do I have my article up to remind me?
Encrypted Media Extensions.
Thank you, encrypted media extensions. And what that is shorthand for is DRM in the browser. Ways of making DRM, digital rights management, function in a browser format. And various W3C, that's the World Wide Web Consortium, members have been going back and forth with the W3C for a while now on this issue, EFF among them, plus some 30% or more of the W3C members have not been wild about the idea of publishing the encrypted media extension specification as a recommendation, thus blessing it as an official web standard. And EFF's real problem with this, to the point where it felt that it had to resign over the fact that it could not persuade the W3C to make a compromise. EFF really wanted the W3C to, if they were going to do this, to build in some exemptions to the DMCA, basically, to make it so that this standard would not have applied to people who wanted to crack DRM for legitimate purposes. And this, if you've listened to the show for a good chunk of our 400 episodes, you know that this is a dance that people go through every 3 years when the process of approving exemptions to the DMCA comes back around again. This is how this federal law works. It's unlawful to circumvent DRM unless there's one of these blessed exemptions that addresses the activity that you're involved in and says, okay, we see you're not up to anything bad or infringing there. You're doing research. There's good reason for that research. It's valuable to the world for you to do that research, and we're not going to get you in legal trouble for doing it. And there are various exemptions that come up again and again every 3 years and have to be argued and renewed every 3 years. Well, EFF wanted W3C to take that process out of the picture for people impacted by this browser standard. Cory Doctorow wrote an open letter to the W3C explaining the EFF's backing out of their organization, resignation from their organization, explaining the compromise that EFF had proposed and was rejected, telling that they wanted the W3C, to make a difference in how DRM was enforced, to protect the openness of the web, to provide some legal clarity for those who bypass DRM to engage in security research, to find defects that would endanger billions of users, or who automate the creation of enhanced accessible video for people with disabilities, or who archive the web for posterity. Those are just, the examples that he provides, but there are various other things too that would be a lawful circumvention of DRM. So W3C said, sorry, EFF, and the other 30% of our members who didn't want us to go this route, but we're going this route. So it's an interesting split because it was sort of EFF and others on one side, but on the other side, you've got, not too surprisingly, companies who have stakes in streaming media like Netflix and Google and Microsoft and Apple, who develop browsers for streaming media and or operate their own streaming media services. So they actually were in favor of developing EME, and so Silicon Valley sort of has split on this issue, and EFF has split the W3C. So Matt, what do you think of all this?
I think that it's a balance of equities, of whether the loss of the right to use the copyrighted material is greater than the value to the companies for copyright. My expectation is that through YouTube and through all these various means, like, people are using content material under fair use pretty constantly, and the ability to bring an action against somebody for simply breaking the DRM really magnifies the ability of companies to protect their rights in areas where they don't necessarily have a legal claim, but the cost of actually defending yourself in a copyright claim is very expensive, as we know in the Naruto case. So it seems to me that this is not overall a good thing, that fair use actors are likely to be pinched by this.
Mm-hmm. Now, I haven't looked too closely at the nuts and bolts of how the EFF and others' proposed compromise would have worked, but I assume there would have been some sort of application that you would make to the W3C that would say, hi, I'm a security researcher. This is the work that I'm doing, and I need to be exempt from your browser standard here in order to do it. Otherwise, I'm going to be cracking the DRM, or in order to do the work I need to do, I would need to crack the DRM, and that subjects me to possible liability. Is that sort of in your mind what would happen there, Emory?
Yeah, I mean, I think you've highlighted part of the. I'm not sure if I am 100% on EFF's side right now for the first time in a long, long time, because the restrictions that they're asking for are, like you said earlier, they're really just an end run around the DMCA. And I think that's great, but I think that if we want to ensure that security researchers and fair users are allowed to circumvent DRM for fair use or for security researching purposes, then the way that we want to do that is by going through and reworking the DMCA. The way that this, I mean, from what it sounds like, I haven't drilled down entirely into their formal proposal, but it sounds like the EFF and their 30% were trying to get the other W3C consortium members that are pushing for this to basically agree through a network of restrictive covenants, which, I mean, doesn't sound like it necessarily provides that much more clarity to individual researchers about what they can and can't do. And as far as the idea of whether or not it's time for the W3C to adopt EMEs, I'm also a little torn from the EFF here, because, I mean, the idea that, as much as it pains me to say this, I think that we're a lot further from the Richard Stallman world of the internet than we were, 10 years ago when DRM first started making the rounds and to, huge amounts of controversy. And these services, Netflix and, I think basically Amazon, every kind of online video streaming service, are already using DRM. They're just using it in a form of, additional plugin like Flash or Silverlight, or their own, dedicated app to do this, which just means that users have to download that dedicated app, or they have to download, Flash or Silverlight. And what we've seen with Flash and Silverlight, of course, is that these massively complicated programs are easier to exploit, apparently, and frequently have security flaws. So it sounds like embedding into HTML5 a sort of way that it can function with specific CPMs. What is it? The encryption DRM tool natively sounds like a step up. If it just gets people, if anything, to be less reliant on Flash and Silverlight. My concern is that it's going to potentially make things more difficult for open source browsers and open source community members that are trying to build software that, you can build an open source web browser, but already trying to get Silverlight to work on Linux is difficult. I'm wondering, I hope that that's not going to present more problems as individual content owners are able to plug in their own encryption methods to their EME. So I'm a little disappointed, I guess. I'm sure that the EFF knows exactly what they're doing, and I'm sure that this, reflects not just this current consternation with the rest of the W3C, that there's probably more under the surface that we're not privy to. But I wonder, do they think that they just the W3C is no longer useful in a consumer protection role? Has it been totally co-opted by people that they feel like are just holding a huge sway over the rest of the organization? I don't know, but my gut is to say that, well, I would hope that the EFF would think that they could be more useful to consumers within the W3C than without.
Yeah, I have the feeling that this debate has been going on in a detailed and lengthy way before this development happened and became news and got on all of our radars to take a look at and examine. But I wonder if in parts of those discussions, the W3C was concerned that if it took upon itself the role of deciding, it's the classic code is law problem from Professor Lessig, deciding in a code-based way and blessing with code who is eligible for what would otherwise be an exemption to the DMCA and who is not on a case-by-case basis. I wonder if the W3C was concerned about the liability involved in that, that they might be in the crosshairs of the persons or entities whose DRM was being abridged for particular individuals or others blessed by the W3C, and that taking on that role is really taking on the role that the legislature envisioned for the Copyright Office as it went through and did these exemptions each year. It's certainly something I would be thinking about if I were in their shoes.
Right. I just found out what the acronym was. It's CDMs, Content Decryption Module. So this proposal for the W3C basically builds into HTML the ability for websites to like an API to work directly with CDMs, content decryption modules. So it's not like it builds DRM necessarily into HTML5. It just allows a really easy way for HTML5 to work with these third-party CDMs, which if these CDMs are narrowly tailored and more carefully designed than huge bloated Flash, and I think that's a positive in that DRM is going to be used. It's better to have not Flash DRM than Flash DRM. But
yeah, I mean, to your point, Emory, I think you're right that the web has become less and less open. It seems like the EFF was hoping for a solution, even though the parallels aren't completely right on, a solution kind of like Creative Commons that sort of did an end run around the law and gave people the option to, we know copyright law is hard to amend and hard to reform, so we're going to do something that just sidesteps that.
Yeah, that's a great analogy.
And it doesn't look like it worked out that way this time. And as we know from watching what's gone on as far as video distribution goes over the last decade or so, streaming is it. It's all about the browser. Who uses CDs anymore? A very small subset of folks, but we'll talk about that more in a moment. So it's almost. I'm sure the W3C has been hounded for this standard for a long time from the streaming companies who are going to, do their streaming inside or out of the browser, but would much rather do it in all ways that can reach the most people, I'm sure. So I guess I kind of see it as something inevitable that the W3C
which is why
to do.
It surprises me that EFF is taking such a really hardline stance on this and resigning over this. I feel like there's, this is not the thing that, it's an odd hill to plant your flag on. But I mean, more power to the EFF and Dr. O and everyone, all the respect in the world. So I'm sure that they know better than I, but
and again,
surprised me.
The qualification on our conversation here is that these, we're not in the thick of it, knowing all the details.
Totally.
And they are. So, but it's a fascinating development and sad on a few fronts. The thing that you noted, Emory, about the web just sort of being less open in general, and DRM still having a huge role in the way that things are distributed, even if that role has shifted over the years. Also, the EFF parting ways with the W3C, I can't feel like that's a good or positive thing. Matt, any thoughts?
I don't know that I understand the inner workings as well as you guys do, but it seems like I think I take Emory's point well, that it seems like it should have been a bigger issue that they were leaving on, and maybe there was politics underneath that we're just unaware of.
Could well be. All right. Let's see. Do we have anything else under copyright we wanted to discuss? Yes, just sort of a cautionary tale. This could almost be more of a tip of the week for us, but we've got several of those, so we'll talk about it under copyright. In the wake of the various hurricanes that we've experienced here in the U.S., a photographer, he is not a professional photographer, but a casual photographer like most of us who uses social media and might document something that seemed noteworthy. His name is Michael Seckler. He's a photography enthusiast based in Sarasota, Florida, and he shot a photo of a couple of manatees who got beached during Hurricane Irma and were promptly rescued. And he was quite happy about that, as I'm sure we all are. But the photo really captured, the struggle of these poor animals in the wake of the terrible storm, and the fact that it's not just humans who were devastated by what went on there. So this photographer got approached by many a media outlet in short order to use this photo that he had taken and posted to, it looks like, Facebook. He heard from Fox, he heard from the Associated Press, and he just wasn't prepared, as very few of us, rank and file, non-professional photographer people would be for how to deal with this situation. And what wound up happening is his photo went viral. It got published in many, many news outlets. He wound up authorizing the various news outlets that approached him to use the photo without getting any compensation. So thousands or possibly millions of people have seen the photo, and this person who took it and posted it never got paid, simply because, and he recognizes this, he didn't really have a plan in place and didn't, immediately know to tell the first news outlet that asked, yes, I took that photo. I have the copyrights in that photo. And if you'd like to license those rights from me for your use, we can negotiate a price and an arrangement as to scope of use. So this is one of those, we were talking about new media rights at the top of the show, Emory. This is one of those instances where I'm sure they probably have a guide that helps people out to know what to do in this situation, so that they might actually get compensated for being in the right place at the right time and taking the right shot.
In fact, part 2 of the book, Don't Panic, is entirely devoted to creating, licensing, and distributing content. You might want to check it out.
Yes. So
Excellent.
Michael Seckler would have enjoyed having that on hand when the phone call came in from Fox, and he's a good cautionary tale as to why you might want to know those rights in the past, all of this, I think, happened far more slowly, and maybe you would think to get an attorney on board and think about budgeting for an attorney and what sort of license fees that you could recover from something like this. But I just, those days are gone. I don't think people, like Michael, are at all in that mind frame. Do you, Gabby?
I see this happen. I have a lot of friends who are journalists currently, and they are scouring Twitter, scouring Instagram to find that perfect shot. And when you're the person who took the photograph, you're so excited that Fox or CNN wants to feature the piece that you've actually taken, right? This picture. And just like the gentleman in this particular story, more than happy to be like, sure, just make sure you give me credit. They want that wonderful little piece of credit. The problem is that a lot of people are going to like that photo. And once it gets to station 2, 3, 4, then you think, oops, about the money. And, it's tough because I think having a plan can be something as simple as deciding as an artist, what are my limits? Do I want to just, for a lot of money, give an exclusive right to one station, or do I want to do a non-exclusive license and make sure that I can get as much as possible? And it's tough because you're essentially the little person in this negotiation against the big guys. In the article, a sample of AP's request came through, and they actually, in their agreement, asked for the non-exclusive license, I think it was, or perhaps it was just the license to sub-license. Yeah, there it is. So they actually ask, and they are expecting to get the right to sublicense all the rights they get. So my guess, and again, I don't know, but folks who have that kind of language are probably getting money for the work that you've taken, that you have a copyright in. And they've done it in a way that's clean, and you've signed it because you're excited because AP is giving you attention. So really being mindful to take the excitement and pause it if you're a photographer, an artist, and really read through what the terms are, because you might be able to change a thing or two and really have an impact, get some money back.
Right. And there are a couple of other points that jump out at me in this, I'm sure, very common scenario. Number one is that media outlets are protected by the First Amendment and on the one hand, and do have strong protection under the fair use doctrine. It's, the factor of their being able to use creative works to report news is favored under the fair use doctrine. So they may be able to use a work like this without compensating a photographer in the right circumstances. They might also, if all they want to do is say reuse or reshare a photograph in whatever platform it's originally been shared in, here Facebook, could be Twitter, could be anything else. The terms of use of all of those sites give other users the right to share around what's been published there. So if AP just wanted to, retweet the guy or share his Facebook post, they could certainly do that under the existing terms of service. It's the fact that they want to make a much broader use of the photo that is problematic for them, and they don't want to, have a photographer come and say, hey, this wasn't fair use, what you did, and have to fight about that after the fact. So interesting can of worms opened by this manatee, and we're just very glad that this and the other manatee got rescued, and hopefully other creatures in the wake of these storms have fared as well. Matt, any other comments or thoughts?
Yeah, the only way to add more complexity to this would be if this was in a national park. As we covered a couple weeks ago,
yes.
There's a rule against the commercialization of photographs taken in a national park. And there is a national park of sorts in Sarasota, and this may have been taken there. So the question would have then been is, could he sold it as a commercial license anyways? And even if he didn't and he licensed it to a commercial venue, is this a commercial activity, and is he subject to fines? That would be a great case to challenge the commercial ban in national parks. But that's what first came to mind when I saw the manatee in the wild. I don't know if it is the national park or not, but it certainly looks like it could be.
So tip to our law professor friends who are listening to the show, this would be a great exam question, this whole thing. So have at it. Where were we going to go next? We were going to take a trip to Hollywood Boulevard and talk about some entertainment related issues. So we had Martin Shkreli in the show last week as our tip of the week. The tip then being don't solicit assault because you could wind up losing your bail and wind up in jail or otherwise wind up in jail. This was over his Facebook post asking people to putting a bounty on Secretary Clinton's hair as she goes around and does her book tour. That was ill-advised. It seems this whole Wu-Tang album thing seems to have been really ill-advised as well. Let's catch you up if you're not up on what happened in 2015. Part of the reason that Martin Shkreli is notorious is not just for his price gouging in the pharmaceutical industry, but because he bought this supposed Wu-Tang album that was a limited edition CD. And here's where we get to whether or not people still listen to CDs. I guess this is one way in which they do. That came in this amazingly gaudy and elaborate packaging and sold at auction to Martin Shkreli for $2 million. And at that point, his rights that he purchased with that album were basically that he could do anything he wanted to with it except sell it. I didn't look at all of the terms, sell copies of it. So if he wanted to release it into the, to let the world's Wu-Tang Clan fans listen to it, he could do it, I think, as long as it was non-commercial. But no, he's chosen not to do that. And in fact, since he's fallen on such hard times and taken to soliciting assault, he decided to sell said $2 million album that he bought, CD in the weird case. But unfortunately, now that he's on hard times, there he is. If you're watching the video, he posted it on eBay with a very pathetic photo of himself and a note saying he's selling it. He fetched just over $1 million for it, so lost about $1 million on it. And now there's this swirling controversy about whether it even is a Wu-Tang Clan album. So in the midst of all his legal woes, Martin Shkreli might have to be hiring someone to look into whether he got what he paid for, whether there was some sort of breach of contract involved when he bought the thing, some sort of fraud in the inducement of the purchase. Because now there is a bunch of speculation that no, this wasn't even what we would think of as a Wu-Tang Clan album. And there's a very detailed piece at Bloomberg that we have in our discussion points, which you can review at your leisure at tagpacker.com/user/thisweekinlaw. Find episode 400 there. And it goes through the various arguments and assertions and firsthand accounts by people who were involved in tracks that went on to this thing about why it's not maybe perhaps a Wu-Tang album. I kind of got lost in the weeds in that article, so I'm going to let others try and sort all that out. Emory, thoughts?
Like, I am not going to disrespect the Wu-Tang Clan, so I don't want to say anything inappropriate.
That was why one of the jurors got bounced from Shkreli's trial. Yeah, he said he thought that he was guilty and had done it, and he wasn't going to let him slide out of anything. And then he added, and he disrespected the Wu-Tang Clan. So, you should. Out, weren't you just on call for jury duty yesterday, Emory?
Yeah, I should have.
Yep. one to file away. So Once Upon a Time in Shaolin still has not been listened to by the public at large. Ziccarelli himself said he didn't listen to it at length or something like that.
I think it's interesting. He did say in the eBay listing that he covenants that he would destroy any copies that he'd made. It's just kind of interesting. I don't know. I haven't really processed this entirely, but he's not only selling the exclusive limited print CD, but he's selling, apparently, according to him, the only copy of the CD that he bought, and I guess he could have made a copy of, but
right.
I don't know. This is getting
shades of the Redigi case, right?
Yeah.
Their technology, whether you can resell digital files, involves assurances that copies of those files are not going to persist when they are resold. So fascinating Wu-Tang related story. Matt, thoughts?
Oh, I'm going to go with Emory here and not disrespect the Wu-Tang. But there was just a lot going on in the network of building an album with people across the country and across networks. Really brings in like vast copyright problems in general, especially when you're not advising your other, if you're not being integrous with your other co-creators of what you're actually making. So there would be an interesting claim here, but it's not in the public knowledge of who the copy itself. So it'll be interesting to see if the purchaser releases this, and then I would imagine that we'll be hearing more about this.
This Bloomberg piece is just full of gems. First of all, we have Domingo Neris, who's on record saying it's not an authorized Wu-Tang Clan album. Domingo is the manager of rapper You God, a charter member of the Clan. He says it never was an authorized album. So we're going to get Domingo and others testifying, I guess, in Ziccarelli's favor when he goes to say, you sold me a bill of goods here, Wu-Tang Clan. And then the Bloomberg actually tried to discuss Once Upon a Time in Shaolin with Martin Ziccarelli. He responded to an email earlier this week, the article says, with ha 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 before castigating Bloomberg LP, which publishes financial data and news. He called them overpriced legacy software that subsidizes a money-losing media company, and declined to talk to them. So, Gabby, anything else you want to add here?
I have so many IP questions. I have to tell you. So my thought initially reading this was, okay, first of all, what qualifies as a true Wu-Tang album? Because when you're reading this story, it sounds as though a lot of members of the, Wu-Tang came in, thought they were doing a feature on someone else's album, but some kind of knew that other people were participating. So how do we define that? I was thinking in my own terms, okay, if the two original members of Destiny's Child who got booted were to release some album and maybe Beyonce was on one song, is that a Destiny's Child album? So, what does that mean when we think about what a band is now versus yesteryear? But also looking even at that very intricate case that was provided in the purchase. Who authorized the use of that? I assume it's trademarked. I don't know for certain. But don't Wu-Tang have to make sure that they are policing their mark? If this isn't authorized, there's a lot of IP issues here too. So for me, there's a lot to unravel.
You know what else this reminds me of? And I forget her name, and I forget it was God, what was the name of the movie? You guys will remember. But there was an actress who sued for having done a part in a movie on false pretenses. Oh. Remember her? She was told one thing, but the movie was about something else. It was about something related to the Muslim faith. And she sued and she lost, as I recall. So as far, and we're going to, somebody in Irish remind me what this case was all about. But yeah, the movie that caused, thank you, Dr. Morbius, the Benghazi attack, or was associated with that. This sort of recording me or recording my performance under false pretenses argument seems to raise its head here as well with these
It'd be nice
Klan
to see these
members.
Agreements too, or there.
Yeah,
I assume were there just a verbal, "Hey, come in, and I want you to just be on my track. It's my mixtape," or was what was the conversation? And also, the record label that owns the rights to Wu-Tang. I'm just curious if they've spoken up officially, if anybody knows, because you would think they'd want to jump in and really examine this piece.
Yeah, absolutely. Matt, give us your thoughts. Innocence of Muslims was the movie. Actress was, hold on, I'm pulling her up. But meanwhile, weigh in for us, Matt.
My assumption is that these sort of arrangements, I would have assumed that the Wu-Tang Clan would have been a little more prepared for this, but this is the way that music and creation and collaboration happens. It doesn't happen with lawyers and contractual agreements. It happens with people getting together and making things and selling them. But I am surprised that they do not have some sort of formal agreement. At least that's not outlined in Bloomberg. But I do think the trademark is really interesting. If they're not actually protecting their trademark and it's a loose collection of people who can use it, what's the value?
Right.
Interesting.
Her name was Cindy Lee Garcia, and she attempted to extricate herself. She argued that it was an infringement of copyright law for them to use her performance in the film because they led her to believe that the movie was a historical adventure titled Desert Warrior. But instead, it's the movie that prompted the riots associated with Benghazi. So, something the Wu-Tang Clan might want to consider, although Cindy Lee Garcia did not fare too well in her suit. So let's see, what else do we have on the entertainment front? We have Vidangel again. We've been talking a lot about Vidangel lately because they lost their appeal before the Ninth Circuit end of July. And I think it's a fascinating company, and it actually really meshes well with a lot of the topics we've been discussing today, including DRM and this new W3C specification or standard, and also CDs and their fate. So as I said, we've talked about Vidangel on the show before. If you're not familiar with it, it has an interesting business model, something that perhaps you would think there might be an exemption for under the DMCA, but there is no specific one. So what Vidangel originally did was it did have to crack encryption the way that it was generating filtered versions of movies, was to rip the movies from DVDs and then provide a decision-making tree for its subscribers where they could take out language or taking the Lord's name in vain or adult situations. Various things were offered. As I learned when I used the service, and this was a while ago now, and they are changing their business model. But there was a time when I forget the movie I was searching for, but the only place it was available, and this should have set off a red flag for me. It wasn't available on Amazon Instant. It wasn't available on Netflix. It wasn't available on demand. It was available through Vidangel. And I went, oh, what is this? And I only found Vidangel because of their app on the Roku. So I looked at it. It was there and available. And their pricing model was the movies were $1 a piece, so they were far less than what you would pay on some other licensed platform. But they made you pay $20 at a time. And then you would, chip away at your $1 a piece. Or after you had rented a movie, and this is what I did, you could cancel your account and get your balance back. So very sort of strange pricing model that I'm sure raised some eyebrows with the movie studios. And the other strange thing when I used the service is the filtering options were certainly there. And if I had wanted to filter the movie that I could only find on their service, I could have availed myself of them, but I didn't want to filter. So I was able to watch the entire uncut, unaltered movie for $1 by using their service. So I'm sure.
So for our listeners here that aren't aware of the four-factor fair use analysis, that goes really, really badly for Vidangel in the fourth factor.
Yeah, there was no transformation.
And the third.
Yeah.
And the first.
Yeah. So and under that business model where they were ripping from DVDs, they definitely were cracking DRM to do that. So they, were going to be in trouble any number of ways. And I think that what they were arguing was fair use, and they have lost on that. But they were enjoined. They're still under an injunction, but they've pivoted. And what they want to do now, since video, most people aren't looking to subscribe to a Vidangel. They already subscribe to Amazon or Netflix or any number of Vudu, various other streaming services that are available. It wants to be the tool that you use in connection with those services to enjoy a sanitized version of whatever it is that you want to watch, sanitized in whatever way you customize. They are forging ahead. They are attempting to get the Ninth Circuit to say that their new business model, where they're partnering with streaming services, does not violate the terms of their injunction. In other words, that they're not enjoined from going forward. And I just think their whole posture here, I think it's fascinating. I think that on the one hand, I think a service like this should be able to exist. On the other hand, they've got to have better counsel because having a business model where you're undercutting and selling for $1 and not actually altering the film when you're relying on fair use, this is legally problematic in so many ways. But somebody is counseling them to put themselves out there and really get the audience behind them as a good guy. And so one thing that they've done recently is put a video out that, what did we call it before the show, Emory? I said it's sort of an advocacy video, and you said?
Advocacy-vertising. Which I feel like is a mouthful. I might need to workshop that word a little bit better, but advocacy-vertising.
That's exactly what this is. And we want to show you a bit of it and talk about what they're doing here and potentially why they're doing it.
Murderers, women are sex objects, and bigoted, profane language is the norm. And the thing is, we do show these movies to the planet's newcomers. They're called kids. That's why we made Vidangel. Vidangel is a streaming app that lets you watch movies and shows and skip whatever sex, violence, or language you don't want to see. And since every family's different, Vidangel lets you customize movies for your specific needs. Now, religious viewers can remove the Lord's name in vain. Trauma survivors can take out trigger scenes. And parents with young kids can cut scary moments instead of cutting a check for future therapy. Looking at you, Fern Gully. Vidangel gives you total peace of mind. It now connects to your streaming accounts like Netflix, Amazon, and HBO, and lets you filter the content you're already paying for. And when a new episode comes out, you can watch it filtered 24 hours later on any major device. All for just $7.99 a month. The cost of a pizza. And the first month costs nothing, like a stolen pizza. So if you want to protect your kids from murder, nudity, or Jar Jar Binks, go to vidangel.com or the App Store to start your free month today. Yeah, we have a Jar Jar filter. Don't like censorship? Neither do we. We don't force directors to change their scenes. We just let families mute and skip those scenes like they would with a remote. A remote isn't censorship. It's choice. And sure, if you think filtering ruins the art or don't want to give money to a movie that needs filtering, Vidangel's probably not for you, and we respect that. But if skipping that one scene will make your movie night perfect, Vidangel is for you, and we respect that more because you're paying us. Hollywood makes incredible movies and shows, but some parts may be inappropriate for your family. Now you can filter them with Vidangel. So download Vidangel and start your free month today.
I think that's probably enough. But the first part of that
is.
video was entirely different in tone and content. The first part of that video, if you do check it out, is entirely about the very real problem of women objectification in Hollywood, and sort of deconstructing some of the more tired excuses around that whole issue. And then it just does this about-face shift and says, and by the way, that's why we made this product. So that's where advocacy advertising. But I think that this is, by the way, their pivoted model now, where they're no longer trying to rip DVDs and then send the streamed DVDs to the customers for $1. This is where they actually have a sort of plugin that lets you I'm actually not sure because I haven't downloaded this directly. Just going by their terms of use and what they describe their service as, you give your login credentials of Netflix, Amazon, whatever your streaming service, to Vidangel. They will then log into the video service and then stream it to you through your authorized account, but with a tool that will allow you to then censor or skip or whatever whatever content that you'd like.
Wow.
So that's really
if that's not a terms of service violation, I don't know what is.
So first of all, their initial plan, like the previous business model that was really messed up, that they got the injunction ordered against them in, was I think clearly violative, and they're not doing that anymore. But yeah, this is a way of getting around that, where they're saying, look, we're not distributing copyrighted content. We are really just giving you a tool that's like a remote control on steroids. So it's not, distributing content if the person at home can choose to just press the mute button on their remote to mute violent acts or to mute bad words. So that is an interesting way of sort of circumventing the fair use argument, is that they're saying they're not actually distributing illegal content at all. They're just sort of distributing technology that allows the user to mute or skip certain sections. That alone, I think, is interesting, but the way that they're doing it definitely sounds like a terms of service violation, because you do have to give your login credentials to these streaming services to this third party, which is prohibited in all of those streaming services terms and conditions.
Right.
So
it sounds like a terms of service violation unless they somehow get the blessing of Netflix and Amazon and HBO and others to allow them to do this, or allow users to. They're going to need to partner with these companies to allow their plugin to work. But I don't think it solves their DRM circumvention problems.
Well, have you heard of the Family Movie Act of 2005?
Yes.
I had not heard about this. Do you have any more details about it? From what I understand, it basically just says that you're allowed to circumvent DRM in order to create filtering technologies, or is that off base?
Vidangel argued that in their case at trial and to the Ninth Circuit, and it did not save them from being enjoined or which is what the situation that they're in now. So the court didn't agree that it applied to them. And we'd need to dig deeper into the reasoning of when the injunction was granted as to why exactly the court concluded it did not. But it did find that they were out of luck under the what is it called again? The Family Movie Act of 2005. I think it was. Yeah. We have a really great article in the show notes from JD Supra that if anyone that's interested in this, I really recommend checking out. It goes into depth. It's called Ninth Circuit's Vidangel Decision Vindicates Lawful Video Filtering Service. And the way they describe it is that the Family Movie Act of 2005 essentially says that it's not that filtering technologies, purely filtering authorized copies, is not a copyright violation. And it was made, it looks like it was basically pushed forward by ClearPay, a small company in 2005 that was dealing with, I think, the same issue that Vidangel is doing, but they were, it sounds like ClearPay was doing what Vidangel is now pivoting to, where they were giving technology to users to then treat the user's remote control like a remote control on steroids. But
Vidangel was claiming that the FMA protected them when really what they were doing is they were ripping unauthorized copies and then streaming those unauthorized copies with filtering. So the FMA says that if you're filtering authorized copies, it's not a copyright violation, but if you're applying that filtering technology to unauthorized copies, then it is. So I think that's where the court was drawing the line for Vidangel. But I had never heard of this idea that filtering technology is okay. It's permitted by the FMA, so I think that's pretty interesting.
Yeah, I mean, it's certainly been a center point for Vidangel thus far. And the one thing that I don't think that Amazon or Netflix or HBO or anybody else who offers streaming services that Vidangel is targeting to get people's credentials and have them use, none of those companies want to be in the situation of being in the crosshairs of deciding whether the Family Movie Act enables them to partner with this company. So I think it's going to be a tough road ahead for Vidangel. But the other thought I had on all this is, if you thought that video that we showed you, and I do encourage people to watch the whole thing, it's a fascinating bit of advocate.
We'll workshop.
Yes, exactly. Advocacy advertising.
Advocatizing. I don't know.
Yes, it's fascinating. I do think that it's a huge effort and potentially an effective one to get Vidangel to come across as the white hat party in this whole scenario. The party that has a legitimate, valid thing that they're providing to society, and that courts should recognize that and take it into account in making decisions about Vidangel and its business model. And it's very slick and well produced, and that might not surprise you once you learn that Dean Harmon, the guy behind Vidangel, is also the guy who did the Poo-Pourri commercials. If you remember those, the funny commercials of a lady in a bathroom stall advertising a product that would make it just clean and wonderful after you have visited said stall. So the guy's got some talent with media and opinion influencing, I would say, and is putting it to work in favor of trying to salvage Vidangel's business model. Totally fascinating, the whole thing, I think. Matt, any thoughts?
Yeah, just the procedural posture of all of this. That this is a preliminary injunction is granted under Rule 65 of the Federal Rules of Civil Procedure, and in order to get one of those, you have to prove 4 elements: that there's irrevocable harm, a reasonable likelihood of success, and whether the injury outweighs the damage to the other party, and the public interest. And so it seems like what Vidangel, in order to get the court to reverse that, is providing elements to, especially the public harm. This video seems like it's going to attack that, and you have to have all 4 of these in order to put in a temporary restraining order or an injunction. So. But on the back end, it's left up to the discretion of the court whether to reverse these. So it just seems like, good lawyering from the start would have gotten them a lot further than a lot of creative ideas and a lot of seemingly useful product on the back end.
Yeah, they really seem to have taken the ask forgiveness, not permission Silicon Valley motto to heart, and you don't see that from a lot of companies I think they're out of Provo.
Yeah, they're in Provo.
So, Just an interesting aside. All right, let us put our first MCLE passphrase into this episode of This Week in Law. And I don't know how it can't be poo-pourri, because that's what it's going to be. We put these phrases into the show in case you are a lawyer or other professional and like to watch or listen to our show for professional education credit in your field. If you are a lawyer and would like more information about that, head on over to wiki.twit.tv, find our This Week in Law page there, and you'll find a chart put together by Franklin Graves way back in the day, and periodically and sporadically updated as we get more information about the various jurisdictions that offer CLE credit in the United States. We are not an approved provider, but we don't have any objection whatsoever, and we'll try and support you in whatever way we can if you want to apply in your jurisdiction to see if you can obtain credit for watching or listening to the show. So some jurisdictions like to have some validation method that you didn't just put episode 400 of This Week in Law on a list. So we put these phrases in, jot them down if you think they will be helpful to you. And next, we're going to move on to some privacy stories. We can't have Emory on the show without talking some privacy law. And so we've got a few things here to mull over with you, Emory. Number one is the point I've seen raised in a number of outlets that Equifax would have been in big trouble come next spring under the GDPR in Europe for deciding not to tell people that it had had a massive data breach for a couple of months. Any thoughts about this?
Yeah, I mean, I'm sure you guys talked. I know that you guys talked about the Equifax breach while I was gone. I have to say that was I was on vacation when I got the email, or when I realized what was going on, and nothing like being at the beach and checking and finding out that you're also part of a data breach. But, you know, I guess that's par for the course with 143 million. It was kind of likely that I'd be part of it. But yeah, I mean, the GDPR, which is the General Data Protection. GDPR.
Yeah.
The GDPR, the General Data Protection Regulation, is a net of general regulations across the EU for data, basically controlling what companies that deal with consumer data have, what obligations they have when that data is breached, and how they are able to transmit that data across countries and across businesses. And yeah, there was, unlike in America, where we have a sort of patchwork network of states that have different data breach notification regulations, the GDPR would set a base regulation for all of the EU that says that no later than 72 hours, outside of a couple exceptions, I think are, I haven't drilled down entirely into the GDPR. There are some caveats with phrases like without undue delay and where feasible in certain circumstances. But generally, yeah, within 72 hours, the Equifax would have had to actually notify everyone that was part of the breach that they were part of the breach. Meanwhile, in America, Equifax has basically said that, oh yeah, we're getting ready to maybe start sending out some emails to people, but you know, they're not doing it yet. And I'm not holding my breath. I mean, the way Equifax handled it here, I think, was emblematic of why we need something like the GDPR, because, you know, instead of being sent to a website that may or may not have malware itself on it, or may not be secure, or may not even be telling accurate information to the people that put in their sensitive information, Equifax would have to actually send out those notifications personally. And then it also says that, you know, the GDPR sets that the companies that don't follow these regulations can face fines of up to 2% of their gross revenue for the year, I believe, or up to $10 or $12 million, whichever is higher. So for Equifax, that would have been about $68.5 million in fines We have a great article from TechCrunch in the show notes that I recommend anyone check out if they want a little more information about it. But the author says that does rather give pause for thought, and I think I agree. If we have a huge problem in America with these data silos and data breaches and unaccountability, and it is an uphill, maybe impossible battle for consumers to fight. But you have to imagine that if companies were facing $60 million fines, they might be a little less likely to have these problems happen, or at least quicker to solve them. So no real thoughts outside of that. Oh, and also this is, obviously Equifax is MNC, multinational corporation. So it's likely that some EU citizens' data was part of this breach, or at least possible. And if not Equifax, certainly this brings up the point that the GDPR is, and these discrepancies and things like data breach notification rules highlight why things like the EU-US Privacy Shield, which controls how easily and how smoothly American and European companies can transmit data between, or can store and use data that are of citizens of the other country. So, it makes things difficult when Americans have a very sort of milquetoast patchwork response to these types of issues that the EU, as codified in the GDPR, think are very serious. So it's all complicated. It's not good.
It's all complicated. It's not good. It's not like Congress is busy or anything.
Nah.
It would sure be nice to see some legislation that address this issue. And 72 hours seems like a pretty tight turnaround, but I sure like it better than I like 2 or 3 months to be able to sit on that data and decide how to let people know.
Well, isn't it 72 hours after? Isn't it 72 hours after you're aware that there has been a breach? Okay.
Mm-hmm.
Yeah. It's not just, you didn't become aware of a breach that happened last week, you're automatically in violation of it. No, it's as soon as you become aware within 72 hours or within what is the term according to the article, without undue delay and where feasible in certain circumstances. So there is, by the way, most of American states have some form of data breach regulations. I think that California's follows the language of the GDPR pretty closely, as far as I don't think they set a hard line of within 72 hours, but they do use language like without undue delay and where feasible as soon as you basically realize it. But because not every state's the same, and some are worse and some are stronger, it makes sort of international agreements and international business for these kind of companies a little more complicated.
Right. Gabby, any thoughts on this?
I can't help but think, let's say that we were going to go ahead and implement, whether it be the 72-hour rule or something a little more stringent, you do wonder if companies are going to be a little more lax, almost a willful blindness on the other end of figuring stuff out, because there is that qualifier of when you become aware. So that, especially with the Equifax breach, was my concern is I believe the unauthorized access happened, they had said in mid-May, and they weren't aware until end of July. So there's a really big issue from identifying the issue to notifying those who were victims of the breach. So keeping all of this in mind as we move forward in developing these policies. And also, the GDPR is imposing a fee, which, the article covers. And the best way to really get a company to move and to act is to threaten to take money out of their purse. So, keeping that in mind too, is what a new U.S. regime would look like. If I was a big company, more likely to make sure that my infrastructure looks good, that I'm developing the requisite tech and making the requisite checks to avoid that additional cost that I don't need to have.
Yeah. I mean, we clearly need some sort of motivation for a company like Equifax. And how many data breaches have we had? Huge,
Too many.
Serious data breaches in just the last 2 or 3 years. It's just, you would think that companies would be practicing the security measures that they need to prevent this kind of stuff, but they're not, and they need motivation.
I don't want to trivialize the problem either. The problem is really hard, undoubtedly, and maybe unsolvable currently. But at the same time, it's clear that, at least in Equifax's case, and most of the other data breach major data breaches we've had, they weren't exactly following best practices. So certainly, at least setting some best practices and some enforcement, requirements to follow best practices is, I think, essential.
Yep, I agree. Matt?
I'm just curious how much in the wake of not having legislation, if there'll be interesting tort damages brought for sort of like on a privacy theory that my information is disclosed, and to see class actions come about as a result of this, to see if those don't, if judges essentially don't take the reins in this. So it'll be interesting to watch. Clearly, I think that what the most egregious fact is that they waited a month or a month and a half before they told anybody. I just don't see how anything was going to get any better by just like remaining silent about it. But
yeah, it's a terribly egregious fact. But I'm back to the point that we need to be incentivizing companies not to let this kind of thing happen in the first place. So there's nothing to tell. And so hopefully we will get there at some point. Another place we thought we were going to get, but so far not in California. If you remember back, we had some FCC rules that would have protected internet users from having their data collected and sold by ISPs without their permission. We had some opt-in, opt-out shifts that happened there. And when we discussed that originally after the election in November, we speculated that states might take the reins on this, and various of them are trying to enact legislation that would basically duplicate what the FCC rules were that got rolled back. California was one of those states until I think it was last week or the week before, when they had a piece of legislation poised to pass, but it did not. The bill is now stalled for the rest of the year. It will get raised again in 2018. But so far, California is not out in front passing legislation that's going to be more protective of what ISPs need to disclose about what's going on with your data and what is needed as far as consent to what they can do with the data. Emory, sad to see this go away for a while.
Yeah, I mean, I think this is super frustrating in that, we were so close to having rules that were basically modeled. I mean, AB 375 was modeled basically entirely off of the privacy rules proposed and enacted by the FCC that were then repealed when Sajid Pai came into his position as the head of the FCC. And, I think I've said before on the show that I think that these rules really, if for anyone that really digs into them, it seems like they're pretty common sense and maybe surprises people that they aren't here already. This is things saying like, we want companies to require opt-in consent to use and share your personally identifiable information with other companies for their commercial purposes. That makes sense. We want companies to require a user to actually affirmatively consent to that sort of behavior. It's not saying that we're not allowing them to do it at all. We're just saying that if you want to use my personal identifiable information for your advertising purposes or for whatever purpose, you need to ask my permission. I can give it to you. And that sounds fair. And for other things, we say that, it only requires opt-out consent. So non-personally identifiable information, you don't have to ask my permission, but you should, I should be able to tell companies that are saying this, that if I don't like it, to at least let me opt out of it. It's saying that your rules and terms about how this is going to be, how and in what ways you share this data have to be made in a very clear, easy to understand way. It's saying that the methods by which a user can give or revoke their consent should be in an easy to use tool. I think maybe I'm a radical privacy advocate or something, but it sounds pretty common sense to me. And so it's really depressing to think that, California, which is a state that I think everyone in the advocacy organization and community thought that, California, this is where we'll at the very least be able to get this kind of legislation or regulation in California. And from what I hear is that everything was looking great until about 2 or 3 days before the vote, and a whole slew of nasty, misleading social media ads, falsely saying that this is going to somehow encourage terrorism or cybercrime or, pedophilia, whatever, pulling up the flags of, against terrorism and saving the children to pass or to defeat really good bills. So it's super depressing personally. I think that, we're going to be seeing legislation like this pop up all over the country. I think New York is doing something very similar right now. Best of luck to New York. And hopefully in 2018, I'm sure that the EFF will be pushing for a renew version of ABA 375. I don't know. Nothing really else.
Hang in there, Emory. We can take
my,
the long view.
My one thought on here is that the one bone I could perhaps pick with AB 375, and not personally, but I could see maybe resistance being pushed to it, is that they included a really broad definition of what personally identifiable information is. And I think correctly recognize that this is not just your name, your social security number, your address, your mother's maiden name, etc., but it includes data that can be, when used in context with other data points, used to identify you. In the privacy world, there's a lot of research lately into the idea of de-anonymization, or is the idea that you can ever truly anonymize a set of data such that you can't, with a few pieces of contextual data, re-identify someone. I think that that's proving to be very, very difficult or maybe impossible. And so maybe ABA 375 was pushing a little too hard in the line that, well, personally identifiable information includes anything that can be reasonably linked to an individual or device, such that with any other piece of contextual information, they can be used to identify that person, including but not limited to name, address, social, and the list goes on, including MAC addresses, IP addresses, and other persistent online or unique advertising identifiers. So you can see where in industry, some giants might, like the Big Five in particular, might be pushing back on that kind of language, because at that point, it's not just biases or broadband internet access service providers that are implicated, but Google and all the advertising giants as well.
Right. Matt, what do you think of all this?
Yeah, I think when a state passes one of these laws, I think it'll still be really interesting to see whether Congress's decision to reverse the Obama administration's privacy policies is going to preclude any state action. It seems, the analysis is straightforward, that the Congress spoke directly on this, and so under the Commerce Power, it seems like they should have the authority to preclude them. So it's interesting that they took away a regulation, but they still have regulations concerning privacy. They're just not as strong. So that would have been a legal fight. What's that?
Preclusion would be pretty hard to show, I think, right? I mean, in order for the issue to be entirely precluded, the government would have to regulate basically all areas of it. But just repealing previously established privacy rules, I think that'd be a far cry from actually precluding individual states from raising those themselves. But that's just me.
Yeah, that's something a court might have to wrestle with, though, whether it's a far cry or not. Gabby, any thoughts on this?
This is just an example of that states are having to step up for the patchwork approach that the federal government's taking. And in particular with this California issue, California is often looked to as the golden state, golden standard, right, as to what other states might want to consider. And so it sounds like they're being careful. Emory had flagged that there may have been some overly broad definitions of, personally identifiable information. So I think they're just being careful. And we'll see what happens. But, until we have more of a federal infrastructure, the states are having to pick up the slack. And we're going to just see how it progresses.
Right. We talk from time to time, more and more frequently these days, about how your devices can be searched and under what circumstances they can be searched. One of the most search-friendly environments is at the border. Whether you're coming into the United States or going into another country, you might find that Fourth Amendment protections and Fifth Amendment protections that might prevent you from having to unlock and divulge what's on your device have gone by the wayside because we have put the security and safety of citizens and airports, et cetera, above those search protections that otherwise exist, at least in the United States. So I just wanted to bring up and flag for people who travel that it's not just your own data on the device that you need to be worried about, and point out that if you are someone who represents others and has their confidential information either on your device or you have access to their information through a cloud service, you really need to be thinking about this when you're traveling. And I mentioned I had a personal, I wasn't searched. None of my devices were searched, but I had a personal brush with this during travel to Canada last year. I was not entering the US and nobody at the US asked me anything or wanted to search anything. But when I was entering Canada, a border agent there was chatting about the purpose of my trip and where I was going and who I was meeting and what I did for a living. And when he learned that I was a technology lawyer, he asked me if I represented any hackers. And I did not, although he might have been meaning it as a joke, his tone didn't really convey that.
It's never funny at the border. There's no jokes at the border.
In that context, I thought he was actually asking me if I had clients who might have been lawbreakers, and that if I had somehow answered that question yes, that I might have been subject to a search of my devices. And by the way, we can question whether, a border agent's use of the word hacker always encompasses someone who is lawbreaking or not. Certainly my use of the term hacker does not encompass always people who are breaking the law, but rather people who like to tinker and play around with technology and see what it can do. So there is some information out there for you. If you are an attorney who travels, if you're not an attorney, then these aren't going to help you that much. But I think if you're not an attorney, you should at least be thinking about whose data you have access to other than your own. Certainly attorneys need to be thinking about this. And there is a formal opinion from the Bar Association of the City of New York on an attorney's ethical duties regarding U.S. border searches. Now, there's a footnote in that formal opinion that says the whole situation the one I confronted, when you're traveling into another country, we're not going to opine on that. That's not our laws. And it's, even more complicated, but just be aware that you confront these issues there too. So that formal opinion is out there. You should read it if you're a lawyer who travels. Also, the ABA is urging, again, this is just for coming back into the U.S. now, urging Homeland Security to revise procedures for searching lawyers' electronic devices and trying to get Homeland Security to acknowledge that, lawyers might actually have access to data, not just their own, but you're able to sort of bootstrap your way into searching other people's data through their devices. So just a privacy issue that's out there that may not have occurred to everybody. Matt, any thoughts on this?
Yeah, I mean, the more we're interconnected with with cloud access to everything, the expansive nature of what this opens up to. I can't think of any bit of data that's relevant that I carry on my local hard drive. It's all in the cloud now, and so as attorneys move more and more to the cloud, this seems like the access that the border security would have is really problematic. So I hope that they revise this, and it just seems it seems beyond the pale.
So Emory, what can we tell people to do practically? You're walking around in the U.S. You're logged into all your accounts. You maybe have some files saved locally, but you're about to go traveling and possibly be subject to a border search. What would you do to have good data hygiene in that situation?
Well, I was thinking about that with the ABA recommendation, because it recommends that attorneys take all reasonable steps to ensure that that client data, privileged data is not lost in a search at the border. So what exactly does that mean? How sort of nuclear do you want to go? I think that practically you should probably just turn your phone off when you're about to go through the border. I think a lot of the borders, they don't even let you're not supposed to have your phone out anyways for whatever reason. But, encrypt your phone and turn your phone off. And if it's, a USB drive, or if it's like if you're traveling somewhere, if I was traveling to another country and I had client information on my computer that I was especially concerned about, I would try to encrypt, make a file crypt or some sort of encrypted folder specifically for that information and put that specifically on a thumb drive or something. But I mean, the number of searches at the border is going up astronomically because they have the ability to, and I don't really see that stopping anytime soon. So it's tough,
right. And then, I mean, you put yourself in the situation, they're not going to just be able to easily access the data on the device if you do encrypt it and it is saved locally. But you're going to find, yourself maybe subject to the question, so what's the password? And then you're going to be stuck there and asking for counsel and trying to figure out.
So I was wondering, I mean, there are ways I can think of to make it physically, like you could just encrypt it with 2 keys and you have 1 key and send a key digitally to someone that you're meeting in Europe or wherever you're going, right? And so that way, I mean, here's the key. I don't know the other 2048-bit character or 2048-bit key because that's impossible, and I do not have it because that's impossible. So there's no way of getting into it. I wonder. So I'm trying to pull it up right now, but it's a may, not a must, as far as whether or not attorneys can allow client information to be searched if it's a national security purpose, or if it's like reasonably necessary to conform with the Border Patrol agent search. So I don't think that there's any must language there. So I don't know. Yeah, I don't know. I wish I knew.
On the 2-bit that you just suggested, let's say that the Border Patrol agent had actually taken your phone and you said, I don't have the code, I don't know. What if they were to send a text to that person and they think it's you? Is there, I guess, another way to consider protecting yourself in that situation?
Well, I don't know. I don't know if there's a way to encrypt a phone, to like do 2-factor authentication on an actual mobile phone. Like I don't know if there's a way to have like 2 separate keys to unlock your phone. So if they have your phone and you're saying like they got your phone and then used your phone to send a message to the person that ostensibly had the second digital key to unlock the encrypted file that you have on your hard drive. I mean, sure, I guess they could do that. I don't know.
Right. Well, we're hard on the heels of talking about Equifax and how it's problematic for third parties to have your data because you don't know what they're doing with it or how they're managing it. But in this particular situation, I don't want data locally on my device.
Yeah.
Matt, any thoughts?
Yeah, but if they're able to hold you up until you give them a password to your cloud computing, that doesn't do you much good either.
Do they really? I mean, I don't know. I feel like maybe I'm naive, but I feel like whatever cloud computing service you're using is not going to be immediately apparent. You have a Google account. Does that mean everything is in Google Drive, or is it in Dropbox, or is it, what are you using? And hopefully it's whatever it is, it's strongly encrypted and maybe not, immediately apparent in a search. I don't know.
I mean, I think that's one of the problems with the recommendations, that there be some sort of exception for attorneys at the border where they can say, look, I'm an attorney. This folder, this drive has, client information on it. And so, the recommendation is that suddenly Border Patrol agents just would only be able to physically examine the device. They wouldn't be able to electronically search the device, which, me, I'm 100% in support of the idea that Border Patrol agents can only physically inspect hardware, but that seems entirely impossible because at that point, wouldn't I just say everything that I have? I'm an attorney. Every digital item that I have, gadget has client information on it, it's suddenly, you can't touch it except to look at it and feel it and X-ray it. It just doesn't seem likely,
Right.
But
right.
I mean, I think the idea that passwords are protected and biometrics aren't, that you cannot be forced to give up your password for your encrypted drive right now is going away. So I haven't read up on that entirely, but I'm pretty sure there's a John Smith somewhere that's been held for like a year now for not providing the key that can decrypt a drive full of allegedly child pornography. So I'm not sure if you actually had to put this into practice at the border and they said that your client is suddenly suspected of, some terrorist act, and you physically don't have the key, or maybe you only have one key to encrypt it, how exactly that would play out. I do not look forward to reading about it, but I'm sure that we will in the next few years.
Yeah. Hey, a little bit more lifting. Let's do one final patent story before we get into our concluding materials. So as I understand it, Matt, the Eastern District of Texas as a preferred venue, or any venue under in the federal court system, is not as easy to get as it once was. Can you tell us why?
Correct. So last year in TR Heartland, the Supreme Court took up what patent venue means, and they said that it has to be the place of business. This year, a case went up to the Eastern District of Texas, where Judge Gilstrap, who we seem to always be talking about in some way, shape, or form, ruled that a single salesperson established a place of business. It was appealed to the federal circuit, and the federal circuit said no, like it requires more than just a single salesperson within the venue, and that did not serve purposes for patent venue. So this helps to cut away from the patent forum shopping that was going on, where 40% of the cases were heard within the Eastern District of Texas, and I believe that it was like somewhere around 20 in Delaware. So so it's a good thing that the federal circuit went with the not only just the words of the Supreme Court, but sort of went with the logic and extended the protection from going to these forum shopped areas where there's Samsung ice rinks in front of the court.
All right. I think that gives us our second MCLE passphrase for this episode of the show. It's going to be forum shop stop. Gabby, anything you want to add on the patent forum shopping issue?
Anybody who's been to Eastern District of Texas knows that an entire industry has been built around this forum shopping. And so it's not surprised that the lower courts were trying to hold on and grasp at straws to keep the cases there. I'm really glad to see the federal circuit did this for some clarity for litigants. And going forward, hopefully we'll reduce the number of cases in places very far away from home.
All right. With that, we will get into our tips of the week, resources of the week. We have several on both fronts. And, of course, and we even got to talk about the PETA animal selfie case again today, our animal selfie of the week. We had bears in Aspen last time around. We have different bears this time. Why don't you check them out with us? We have a trap cam that was set up and got some pretty amazing bear footage and audio. If we can give them the audio, Victor, that would be great. I hope that you're able to watch the video, because you're getting just like the best bear scratching back, belly, neck, everything on a nice rough tree, and just having such a good time of it. Just, you can tell this bear is just like getting that right spot. It's this bear is my Patronus when I've got an itch I can't reach. Gonna channel it. I'm not quite sure where this is. It was captured by, it's in Washington State, the Washington Department of Fish and Wildlife, by one of their trap cams. So we've got video and audio not taken by the bear itself or even with the bear's knowledge, but not taken by a human either. So we, I think our show consensus on this, and we don't know if a court will back us up or not, is that the humans who set up the trap cam have the copyright to that video, but that's not entirely a settled issue. Emory, any thoughts?
I think the Copyright Office would agree with us. But yeah, I think that the more and more I see of these, it's, whoever is creating the circumstances by which the photograph or video can be captured with the intent that it be captured, I think should be the author of the work. But yeah, keep them coming, guys. Keep sending them in.
Yeah, absolutely. Love that one. Let's see, Matt, you can do our first tip of the week. What are robots now?
We have molecular robots now. So the basic building blocks of organic life can now be built by robots. I believe it's in Germany, I think Frankfurt. There is an article that we have in our show notes on the first molecular robot, and it can build molecules. And this is like, in terms of like developing nanoparticles and all of this, and being able to design new forms of medicine, everything. We don't understand enough in a lot of areas to be able to do this, but it is on the way, and this is very exciting for that.
All right, so look for the molecular robot near you. Also,
with a very strong magnifying glass.
Yes, exactly. Very strong. Also, hey, kind of near you, Matt, is this pop-up bar you should check out if you can, if it's still in operation. The Stranger Things pop-up bar in Chicago's Logan Square, decorated to look like the Netflix series Stranger Things, triggered a cease and desist letter, which triggered our tip of the week, which is that every cease and desist letter, whether you're Netflix or anyone else, should be written like this one. This issued from Netflix Legal. It was available on Scribd in its full, what do we call that? Letterheaded form. But it got pulled off, at least the version that I was looking at got pulled off Scribd. So I don't know if Netflix DMCA'd Scribd about this or not. But fortunately, Business Insider copied it. Here is the text from Netflix Legal to the folks operating the Stranger Things pop-up bar in Chicago. Danny and Doug, my walkie-talkie is busted, so I had to write this note instead. I heard you launched a Stranger Things pop-up bar at your Logan Square location. Look, I don't want you to think I'm a total wastoid, and I love how much you guys love the show. Just wait until you see season 2. But unless I'm living in the upside down, I don't think we did a deal with you for this pop-up. You're obviously creative types, so I'm sure you can appreciate that it's important for us to have a say in how our fans encounter the worlds we build. We're not going to go full Dr. Brenner on you, but we ask that you please, 1, not extend the pop-up beyond its 6-week run ending in September, and 2, reach out to us for permission. If you plan to do something like this again, please let us know as soon as possible that you agree to these requests. We love our fans more than anything, but you should know the Demo Gorgon is not always so forgiving. So please don't make us call your mom.
Best ever. Best this letter ever.
Seriously, we've had a lot of good ones, but this one really, really ranks up there. So bravo, Netflix Legal. And Matt, you better get over there. They're closing down after a 6-week run sometime this month.
I've got to watch Stranger Things first. I haven't seen it. So,
or actually, I mean, we have no idea if they're closing down, but that's what Netflix has asked them to do. And I have the feeling I would comply if I got this letter. Emory, any thoughts?
I mean, it's on a serious note, I think it is something to aspire to as an attorney, to be able to write letters like that, that can get across the legal point, but do so in a friendly and common English kind of way. Not only do people, I think, respond way better to a personalized letter than to a block of, legalese that's just threatening fire and brimstone. But, it I think reflects better on the profession as a whole.
Yes, absolutely. And not only, effective to achieve your goal in getting the pop-up bar not to operate. Notice they didn't tell them, close your doors tomorrow. They let them play out their run, which was generous of them. But also from a PR standpoint, God, what a dream for the PR department, right? Our lawyers are people too. Yes, everyone who sees this, I think, has nothing but good feelings for Netflix about it. All right, several resources for you. The first is via Al Spalding, who wrote in to let us know that Security Now had featured this. I believe we have featured it on the show before, but heck, let's bring it up again. It's called TOSDR. What's the TOSDR.org, which stands for Terms of Service Didn't Read.org. And this is a great way to see if the terms of service that you are dealing with have been reviewed by the site. And if they have been reviewed, you might see that they've been given a grade, a traditional like A to F grade. And there are a couple of A grade examples. One is a French blogging platform called Seen This. One is called Collab Now, which I actually hadn't looked at before the show, so I'm not sure what it is. But looks like it's Swiss. LastPass gets a B grade. Various companies are still under review, but it's a great concept, I think, to help people understand just at a glance. Are the terms of service I'm dealing with super advantageous for the company and not for me? And am I really giving up a lot by dealing with them? This is a good place to start to try and figure that out. So thank you, Al, for pointing out TOSDR.org. We hope that you'll all check it out and hopefully use it. Let's go next, since it's an actual physical thing, to Geek Girl Rising, which is a book that I wanted you to tell us more about, Gabby. Are you featured in the book?
So I'm not featured in the book. I'm actually one of the folks on the website. This is a phenomenal book. About, I think it was end of 2014, the authors of the book sent out on LinkedIn a request. We want to hear the stories of women in tech, end quote. And a ton of people reached out to them, and they got a really great sense of folks who are leaders in the women in tech space, from, corporate leaders to lawyers to engineers, you name it, they had it. And so the first part of the process was focusing on these women who were telling their stories of how they got into tech, a lot of them from non-traditional areas, including myself, since I do not have a tech degree, but I jumped right into tech law. And it was a bigger conversation about what's wrong, what's working, and if I'm a woman and I want to get in technology, what should I consider? And so they've put together this book, and they've highlighted some of these stories of the women who shared in the initial request for stories. And it's a great read, and it's it's inspiring, and it's worth going out and getting the book and taking a read.
Wonderful. Thank you for letting us know about that. We want to let all of you know that next week, if you're in Washington, D.C., and you have time between 8 a.m. and 5 p.m., the wonderful organization Public Knowledge, in conjunction with EFF, the Center for Media Justice, Common Cause, and various other organizations, are having a net neutrality day of advocacy. You can physically go there to participate. They're going to have a hill walk. They're going to train participants. They're going to have people go to Capitol Hill to tell their stories to their representatives in Congress. And then they're closing out the day with happy hour. So seems like a great way to make your views on net neutrality known in an effective way. And even if you can't be there in person, you can use hashtag Day of Advocacy and hashtag net neutrality to follow and share the event next Wednesday, September 27th. And then another thing to mark on your calendar, if you've enjoyed this show with Emory and Gabby, you can get more of the two of them together on a panel coming up in LA. When is that, guys? And what will the panel be about?
Okay, well, I was going to say October 11th at 11 a.m. at the ABAIP conference, right? You're going to be doing?
Absolutely, yeah. So we have a group from the Internet Law and Policy Foundry, of which Emory and I are both a part of, and we're going to talk about disruptive technologies in the law. So we'll get to nerd out and talk about where we're going with some of these really fascinating new technological advancements.
And some of the topics range from health tech to machine learning and AI to we're going to talk a little bit about VR and AR and the Internet of Things, of course.
So it's in Los Angeles. It's October 11th. What time did you say it was?
I think our panel begins at 11 a.m.
11 a.m. And do you know the location?
Maybe I can add it in post.
Yeah, I think it's in Long Beach, but we will follow up in post.
Great. We will, when we get the link to the event, we'll put it in our discussion points for the show. You can find those on Flipboard. Flipboard is where we sort of sandbox ideas for the show. You can become a Flipboard contributor if you'd like. Just email me. I'm Denise at twit.tv. If you are a Flipboard user and want to add things to our This Week in Law magazine there, when people do that, we use that as sort of, somebody thinks that we should talk about this on the show, so we'll think about that. And also, when I go through and do our rundown each week before the show, everything that I know we're going to talk about or we hope to talk about, that gets put on Flipboard too in that magazine there. So I'm D. Howell on Flipboard if you want to check that out. Also, as I mentioned, we have a list just of all the links to everything that we've talked about on TagPacker. That's at tagpacker.com/user/thisweekinlaw. Episode 400 we have just concluded. So thank you so much for being with us. If you've been there from the beginning or if you just tuned in from today or somewhere in between, we love doing this show, love getting together and talking about these issues which we find important and entertaining and absurd and all of those things in turn. I am so grateful to all of you for joining us each week at 11 o'clock Pacific time, 1800 UTC is when we record live. So grateful to all of our wonderful panelists, the people who have co-hosted with me over the years. It's such a joy to be able to do this. It's fun for me, intellectually stimulating, and so great just to get together with the folks who love the show and even the folks who are just stumbling in and looking for some good information. Hopefully you'll love the show too and tell some friends about it. If you're wondering how you can enjoy the show, you can go to twit.tv/TWiL. That's the show page. It's got all of the episodes of the show going back to its inception. If you'd like to see what we've been up to for 400 episodes, they're all there. And what else is there is suggestions for how you can enjoy the show on your device of choice, whether you like to kick back in the living room and watch it on a big screen or a little screen, whether you're in the gym and want to watch it on a big screen or a little screen, wherever it makes sense, driving around in the car, whatever device, we're there for you. And we are thrilled that you're there for us. If you do enjoy the show and want to leave a review on your platform of choice, that is always fun. Even if you don't enjoy the show, maybe particularly if you don't, let us know, leave a review, and we'll try and address whatever is bugging you. You can get in touch with us between the shows too. As I mentioned, I'm Denise at twit.tv. Emory is Emory at twit.tv. Matt is Matt C at twit.tv. Give us a shout. Let us know what's on your mind, what 2 cents you want to put in, who you think we should have on the show in the future. All those things are super important and helpful to us. This has been really, really fun. Emory, great to see you again. Still all the digits crossed. Of course, you're going to let us know. We'll give you a wide berth.
I'm not going to tell anyone if I don't pass, though. So if I don't
November. Yeah, no, it's hard. It's hard.
A long way.
But we're pulling for you, and we have faith. So it's just a torture that you've got 2 months left to wait. But you'll hang in there. Hopefully, you're taking the time now to have a good breather and decompress.
I had a great breather to decompress last month. I'm at the point now where it's scrambling, but I'm enjoying myself. I've got lots of time for lots of projects, so excited to be back on TWiL fairly regularly in the future. So thanks for having me, guys.
Yes, we're excited about that too. Hey, Matt, it's great to see you again. Thank you so much for joining us. Please give us your review of the Stranger Things pop-up should you get over there, and enjoy the slants. When are they going to perform at Notre Dame?
I believe it's next Friday, so it should be a good show. But as of 14 minutes, it's officially been fall. So welcome everyone to fall.
That's right. That's right. It is the first day of fall. Hooray!
I'm in San Diego, so I guess that's a thing that happens in the rest of the country. I don't really know.
You should come to the Midwest. You'll get a taste.
Here in Southern California, we get clearer skies in the fall, which is a good thing. And a little bit more cold, crisp weather, but not really the changing colors. How about you, Gabby? Are you looking forward to the change of seasons here?
I am. So in DC, though, I will say it almost hit 90 this week. So we're having a little bit of an identity crisis with the fall. But I'm ready. Give me the sweaters. It's that time. So we've had quite a muggy season.
Yeah. Well, there's yet another hurricane that's going to drift by off the coast, if I'm not mistaken, in my weather tracking viewing.
Someone has turned the SimCity slider up way too high. Fix it.
Yes, please. Don't let us all on fire. All right, Gabby, we can't thank you enough. You're superhero for jumping in last minute to join us today, too. Really appreciate your adjusting your schedule to make that happen.
Thank you. And a quick plug. So if you love listening to Denise, you should totally subscribe to the Hustle Over Entitlement podcast, which I'm hosting with my co-host Camille Stewart. And we are telling the story of trailblazers and risk takers, and Denise is a natural fit for that particular topic. So you get to hear her story. And we are launching October 10th, and you can subscribe on Google Play, on Stitcher, and of course on iTunes. So please tune in and you get to hear Denise chat about her life and her story.
Love it. Thank you so much for inviting me on your show, and I'm really looking forward to its debut.
We are too. You're a rock star. For those who don't, you already know if you're listening to TWiL, but she's an absolute rock star. We're so excited to tell that story. And she's like, no, please stop. But it's true. I'm going to give that moment of you rock.
That's very, very sweet of you. I've got to say, I'm much more 400. Comfortable. Yeah, I'm much more comfortable in the position where I'm asking you questions. This worked well for me today. All right. Thanks so much, everyone, for joining us. And we'll see you next week on This Week in Law. Take care.
Denise?
Yes.
I do have some for the 400th episode. Like, we are celebrating here at the office. So we had some donuts for the 400th episode. They were totally not for Alex's birthday. They were for the 400th episode.
I appreciate you. You have my permission to share them with everyone for Alex's birthday. How about that? They look delicious, by the way.
Yeah.
Congratulations, Denise.
Thank you so much.
Yes.
Congrats. All right, everyone. Take care. We'll see you next week.
All right. 400 more episodes.
Woo!